Next to gun control, abortion is probably the most controversial and divisive issue to hit the American people in modern times. Ever since the United States Supreme Court made abortion a legally protected right with its landmark 1973 Roe v. Wade decision, the issue has divided the American public along every line imaginable, with sometimes violent and very often tragic side effects. And now, a leaked draft of a new United States Supreme Court decision, expected to be finalized sometime this month by the current and more conservative iteration of the Supreme Court, that aims to overturn Roe v. Wade, has brought tensions to a boil once again. What if I told you that, for purely legal and non-political reasons that have nothing to do with anything people on either side of the issue cite to support their positions, both iterations of the Supreme Court decided incorrectly? In this video, I will examine the abortion rights issue from that perspective. So, stay tuned, because no matter which side of the issue you plant your flag on, my conclusions may surprise you. I'll put links to both decisions in the video description for anybody who wants to review them, but I won't cover them in detail here because they're both too long to cover in a reasonable amount of time on a platform like YouTube. The important thing to note about both is that the crux of both decisions centers on the Due Process Clause of the 14th Amendment. Roe includes the right to have an abortion under a wide umbrella of personal liberties protected by the clause, while Dobbs spends its time disputing and deconstructing the reasoning put forth in the Roe decision and its follow-up case, Planned Parenthood v. Casey, in order to put the decision on abortion rights to the states and the people under the 10th Amendment. So, how can a claim like the one I made in the intro possibly be true? How could the iteration of the court that decided Roe and Casey and the one that decided Dobbs both be wrong? Well, to see that, it's necessary to take a look at another clause of the 14th Amendment, the Equal Protection Clause, in another Supreme Court case, Skinner v. Oklahoma, that used that clause to set reproduction as a constitutionally protected right. Section 1 of the 14th Amendment, which contains both clauses, reads, quote, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." The 1942 Skinner v. Oklahoma case held that the Oklahoma law in question that would allow the state to forcibly sterilize any inmate convicted of a crime 2 or more times was unconstitutional and in violation of the Equal Protection Clause because, in the words of Justice Douglas, quote, "We are dealing here with legislation which involves one of the basic civil rights of man. Marriage and procreation are fundamental to the very existence and survival of the race." Unquote. In other words, every human being, whether male or female, has the right to produce children. Now, especially if, as I have, you've read both decisions in their entirety, it's fairly easy to see how the 1973 court reached its decision in Roe and how its 2022 counterpart came to their decision in Dobbs. The court's holding in Roe seems to be based on the reasoning that the mother's right to autonomy over her own body holds because a person not yet born is not fully a person entitled to the protections of the Equal Protection Clause. And the 2022 court is technically correct that the right to have an abortion does not appear anywhere in the text of the Constitution. But when you take a second, closer look at the Equal Protection Clause and the Skinner versus Oklahoma decision derived from it, they work together to throw a very big monkey wrench into both decisions that calls their legitimacy into question, even if you accept the reasoning of either or even both decisions as solid and valid. Several, in fact. In the next segment, I'll go over them one by one. Ratified in 1868, the 14th Amendment, in particular the Due Process and Equal Protection Clauses, found in Section 1, is the most frequently litigated amendment to the Constitution. Originally written to ensure that black Americans enjoyed the same rights and legal protections as white Americans, the amendment has, through these two clauses, expanded and evolved over time until today, when the Due Process Clause includes liberties not conceived of by the original authors, and the Equal Protection Clause has come to mean that a level legal playing field is required for all Americans. Just as Roe v. Wade would do 31 years later for abortion through the Due Process Clause, the 1942 Skinner v. Oklahoma case added procreation to the list of fundamental human rights protected by the Constitution when the Supreme Court ruled that Oklahoma couldn't forcibly sterilize criminals who had been convicted 2 or more times because the right to have children is a fundamental right held by all people and thus protected by the Equal Protection Clause. At first glance, it looks like Roe isn't just covered by the Due Process Clause but in line with the Skinner decision under the Equal Protection Clause as well. After all, if the government can't step in to prevent a person from making the choice to become a parent, they can't force parenthood on someone either. Sounds logical, but there's a problem. As I said in the last segment, several problems, and not just for Roe. The same problems extend to the 2022 DOBBS decision that overturned it as well. And all of those problems have the same root cause. When you look at it closer, Skinner v. Oklahoma is just one edge of the double-edged sword with a needle-sharp point at each end, that is the Equal Protection Clause. And, as I'm about to show you in the course of this video, there's just no legal way around it without somebody's rights getting sliced or gutted. Which brings us to the first problem, the inherent and unavoidable inequality of the issue. The inmate in question in the 1942 case was male. Thus, by ruling that procreation is a fundamental civil right of the species, the Supreme Court declared that everyone, male and female, has the right to make the choice of whether or not they want to produce children. Yet, thanks to the accident of evolution making biological men unable to carry children in combination with the lack of technology to produce artificial wombs that could support a developing child from implantation to full term, the level legal playing field required by the Equal Protection Clause cannot be achieved. On the one hand, by putting the matter of parenthood and pregnancy exclusively in the hands of one half of the country's citizens, Roe v. Wade effectively cut the other half of the population's right to make that choice for themselves, as guaranteed by Skinner, off at their risk and violated the Equal Protection Clause in the process. On the other, women are right to be concerned that the fallout from DOBBS v. Jackson Women's Health could do the exact same thing to them in many areas of the country. They are rightly concerned that the impact from the decision could affect them financially, educationally, mentally, and emotionally. But, on that same token, and I know there are some of you watching who will scoff at this, the truth is that they're now experiencing what their male counterparts in American society have had thrust upon them in the 49 years since Roe was decided. That might be an easy thing for some to roll their eyes at, but consider. For every one man heartbroken because his female partner had an abortion that he didn't want, there's at least one, if not dozens more, who are either worried about how they are going to make ends meet, or else are in jail for refusing to meet their financial obligations because the women in their lives chose not to abort. The second, even more serious problem stems from the combination of the inherent inequality of the pregnancy and abortion issue with the Equal Protection Clause. And it is a problem that should become immediately obvious with the Dobbs ruling. While the Supreme Court is, as I stated, technically correct that the right to have an abortion is not mentioned anywhere in the Constitution, and that under the 10th Amendment, any right not explicitly mentioned therein reverts to the states and the people to decide, the Equal Protection Clause expressly prohibits states from making or enforcing laws that deny anyone in the United States equal protection of the laws. Because biological men cannot become pregnant, that means equal protection of laws cannot be applied to this issue, and therefore, if the right of procreation afforded to all Americans by Skinner versus Oklahoma is to remain intact, the states are prohibited from legislating the abortion issue in either direction, for or against. Now, there is no equal protection clause on the federal level. But before supporters of Roe v. Wade rejoice and wait for Congress to pass legislation codifying its precepts into law, not so fast. It is well established that the 14th Amendment's Equal Protection Clause extends to the federal government if the issue in question violates the 5th Amendment's Due Process Clause. Since there's a case to be made that both Roe and Dobbs violate the 14th Amendment's Equal Protection Clause by interfering with one sex or the other's fundamental civil right to choose whether or not to procreate, and because both decisions root their reasoning in the Due Process Clause of the 14th Amendment, there is also a case to be made that any such legislation in either direction also violates the 5th Amendment's Due Process Clause, which would, in turn, make any federal abortion law just as unconstitutional as any such state laws. All things considered, it seems likely that the current iteration of the Supreme Court would overturn any legislation passed by Congress to codify Roe as such, even if they don't acknowledge their mistake with Dobbs. But, dear viewer, the problems for Roe and Dobbs, as well as any potential legislation passed by Congress to codify abortion rights into law, don't end there. The third, and arguably the biggest problem for any Supreme Court decision or any federal or state legislation for or against abortion, is that there's just no workable legal solution that would legitimize it by providing the level legal playing field required by the Equal Protection Clause. Short of removing the need for equal protection completely by doing away with the due process clauses of the 5th and 14th Amendments, as well as the Equal Protection Clause, which would set the clock on civil rights in this country back to before the Civil War, the only way, at least that I can think of, to bring about a level legal playing field would be to enact legislation that violates the Equal Protection Clause, Skinner versus Oklahoma, in both due process clauses just as egregiously as Roe and Dobbs both do. Male reproductive rights is a subject that I've been interested in for a number of years, since long before Dobbs came along. So I've thought about this a lot over the years. And even, or perhaps especially, with Dobbs on the books now, the only way I can see to make any legislation on pregnancy and abortion equal and fair for all Americans would involve doing three things. 1. Making it impossible for a woman to become pregnant before she is ready by mandating contraception for both men and women until they each submit to the government in writing that they feel ready for parenthood. 2. Have men and women sign negotiated and legally enforceable contracts detailing the rights and responsibilities of each party in the event of a pregnancy prior to having sex. And 3. In this age of assisted reproductive technology, place all parental rights in the hands of the prospective parent or parents rather than the surrogate mother, both before and after the birth. This would make the surrogate criminally responsible for murder and or destruction of property should she choose to abort without the prospective parent's consent. Kidnapping should she choose not to give up the child after birth, and grand larceny in either case because she was paid to carry the child determined surrender at birth and didn't. See the problem? All of that would put even more government control over the sexual and reproductive freedoms of all Americans. And every single law and Supreme Court decision we have on the subject says you can't do that either. Alright, now, before I go any further, let me say that while I do have a background in doing research, gathering supporting evidence, and interpreting that evidence, I'm not a lawyer. I'm just an average person reading and interpreting the law from an average person's point of view. As such, I'm not taking any moral or political stance on this issue. I'm just reading the text in front of me and doing my best to make sense of it. It's possible that my analysis is off base, and I welcome anybody with more knowledge on the subject than I have to correct me on any points I may have gotten wrong in this analysis. And it's from that average point of view that I can say that after more than a week of reading Supreme Court decisions, constitutional amendments, and trying to find out what experts have to say on the subject, everything I've found has led me to the conclusion that, for the reasons I've discussed in this video, the issue of pregnancy and abortion is unique among civil rights in that it is the one area where fair and legal legislation, something that is necessary in any free democratic society, in either direction, regardless of a person's moral or political views on the issue, is impossible at either the federal or state level. So, if we can't fairly legislate the issue in either direction, and we can't enact the type of legislation that would make it equal and fair for all Americans, where does that leave us? Well, believe it or not, there is a door number 3 on the issue. Unfortunately, as long as the Democrats and Republicans keep their heels dug in, arguing over the morality and ethics of the issue, it's a door I fear no one in any branch of the government at any level will ever be willing to take. Complete and total neutrality. As I was doing all the reading that led to this video and getting eye strain like you wouldn't believe from spending hours upon hours staring at my computer screen, I couldn't help but think of the 1983 movie War Games as I came to the conclusion that legal neutrality is the only solution that works for this issue. In the movie, Matthew Broderick plays a hacker who accidentally breaks into the government computer, an AI called Joshua, responsible for launching the country's nuclear missiles, thinking it's just a game company's computer full of games that haven't officially been released yet. He picks a game called Global Thermonuclear War and takes the side of the Soviet Union, unaware until he's arrested by the feds the next day that it's a computer war simulation. Trouble is, Joshua, being a computer, can't tell the difference between reality and a simulation, and the computer believes that the attack on the United States from the Soviet Union is real. And the computer locks the people at NORAD out from the controls and begins to brute force the launch codes to launch the United States' entire nuclear arsenal at the Soviet Union in response. In the final scene of the movie, Broderick's character teaches Joshua the concept of futility and convinces it to stop the launch by getting it to play a game of tic-tac-toe against itself. After stopping the launch, Joshua says, "A strange game. The only winning move is not to play. How about a nice game of chess?" It is my opinion, after doing all this research, that the only winning move in the abortion issue is for the government not to play. That is to say, take a neutral stance and remain completely silent on the issue. Had the Supreme Court in 1973 with Roe v. Wade, 1993 with Planned Parenthood v. Casey, or 2022 with Dobbs v. Jackson Women's Health come to the same conclusions I have in the course of making this video, that any attempt to legislate the issue violates both the 5th and 14th Amendments, it would have effectively barred Congress and the states from making laws either legalizing or criminalizing abortion. Now, this would mean that, 1, the federal and state governments could pass legislation that abortion, if it is done, must be done in a way that is medically safe. 2, abortions would be neither legal nor illegal at the federal level or in any state. And 3, the procedure could therefore still be done, but the clinics would have to be privately funded, as no governmental body within the United States could intervene either for or against what must be considered a private decision by all Americans. Okay, everybody. I know this was an unusually long video on a controversial topic I usually wouldn't touch on this channel. If you've made it this far, I thank you for watching. But with everything going on in the country right now, I felt like this subject needed to be explored. If I've offended anyone with my conclusions in this video, I apologize. It was not my intent. I made this video, after all, because I believe in equal rights for all people in this country. Anyway, if nothing else, I hope you found this video thought-provoking. That's it for this video. I love you all, guys, regardless of your political or moral opinions on this or any other issue. Keep being who you are and doing what you do. Until next time, peace.